The first cornerstone is entity formation. Now, this is mostly for people that are entrepreneurs, small businesses, and people looking at retirement careers. But I think that the principles here do apply to everybody, so everybody can take something away from this. We can talk about entity formation and go through all the different entities that are available, but I'd like to focus in on these four things. To start with, there are a number of entities that you can form in the state of Michigan. You can do a sole proprietorship, which is just you. You can do a partnership, is a general partnership or a limited partnership. You can do a corporation, either a C Corp or an S Corp. You can do a limited liability company. Or you can do a professional service corporation, and that involves licensed individuals like attorneys, physicians, and architects. Now, regardless of what type of corporation you want to form, you need to ask yourself these four questions or think about these four ideas. The first one is the setup process. Now, there are sort of two spectrums to the setup process. There's sort of the simple and cheap setup process, and that would be sole proprietorships and partnerships. Oftentimes, there's not formal documentation that needs to be filed. You may just need to go get a doing business as filed with your county where you're going to do business at. Then on the other end of the spectrum is the more complex and time-consuming process. These involve corporations and LLCs. The reason that they are more complex is the documentation that needs to be filed requires a lot of conversations about what it is exactly you're trying to accomplish with your entity, and there are other requirements under the law for these types of organizations. The second issue is taxation. Now, taxation, I think, is one thing that people are always concerned about when starting a business, is how much money am I going to have to pay Uncle Sam? Well, on the one hand, we have what I like to call pass-through taxation. Pass-through taxation is where the income generated by your company is reported on your personal tax return. Your company does not file a tax return itself. These entities would be sole proprietors, the different partnerships, and limited liability companies. On the other hand, we have what's called double taxation or dual taxation, and these are for corporations. Now let me explain dual taxation. Dual taxation happens because the corporate entity, your corporation, is taxed by the state of Michigan with the small business tax or the business tax that is currently in place. Then the income that you are paid by that corporation is also taxed as your personal income on your income tax return. So ultimately, the revenues that are generated by the company are taxed at the corporate level and then again at the individual level. The third issue is liability. Now, liability is an incredibly important issue because it has to do with what happens when things go bad. Now, with a corporation or a limited liability company, you have what's called a corporate shield. The only thing that you can lose in those situations when you have those entities is your investment in that corporation or LLC. But it does not allow you to be penalized or have to be responsible for paying the debts of the organization yourself. Now, with sole proprietorships and partnerships, every liability of the company, whether it's a lawsuit, an unpaid bill, or whatever, is your personal responsibility. There is no shield to protect you from what it is that you would have to pay. The fourth issue, which we'll talk a little bit more detail on the next slide, is management control. Now, the greatest level of control and the most flexibility with management comes at the one end where you're a sole proprietor. It's just you. You don't have to account to anybody else. Partnerships are also sort of within that realm because there are not formal requirements for management and control mechanisms. In limited liability companies are near that level of management control because the law allows for a lot of flexibility with those particular types of entities. On the other side, though, corporations have very strict requirements under the law for both management and control. The second cornerstone that we should talk about is defining relationships. Now, this goes into the management control issue we talked about a little bit, but I want to break down for you the two most common entities that are used in the state of Michigan: corporations and limited liability companies. With corporations, you are required to create your corporation through articles of incorporation. These are public documents that are available to be searched and allow people to know who it is that formed the corporation, where the registered agent is, etc. Corporations are generally run by directors and officers. The directors are typically a board of directors that are elected by the members or the shareholders of an organization, and the officers are your executive officers, your CEO, CMO, CFO, COO, that carry out the directives of the board of directors. Now, as I said, the management control issues in a corporation are very strictly governed by Michigan law. Michigan law requires that bylaws be created. The bylaws explain how management in the organization works, how decisions are made, how board members are elected and removed, etc. Everything sort of related to running the company must be outlined in the bylaws. And then again, decisions are made by the directors on how to enforce those bylaws to different situations, and even how to change the bylaws if the situations require. Now, limited liability companies are very different. They require articles of organization for their formation, which those two are public record. But as far as the management control, it is nowhere near as stringently governed by the law. Typically, a limited liability company is governed by what's called an operating agreement. Now, the law does not require you to form an operating agreement, but I strongly recommend that you do. And the organization will be run by the members, meaning all the people who own shares or stakeholders of the limited liability company, and they can manage it themselves, or they can elect to have members manage your organization. This is very similar to having a board of directors. So it's important to define these relationships because, you know, you start a company, you start a project, you have a very good relationship with your partner, you think everything's going to go great. But what you can't account for is what's going to happen in the future. What is it that you guys are going to do when you fall on hard times? What if one of your partners dies? What if you want to add a new partner? What if somebody wants to be bought out? What if you collectively want to sell the corporation or the limited liability company? You have to define those relationships up front, because when things get dicey down the road, it is not the time that people are going to feel very amicable to define those relationships. The third cornerstone is what I like to call internal contracts. Now, I basically break these things down to employment contracts and employee handbooks. I will tell you that both of these are incredibly underutilized, especially by small businesses in the state of Michigan. Now, employee contracts can cover a lot of different issues, but I think that there's four main issues that you really want to cover in your employment contract. Here, you want to define that they are an at-will employee. Now, the law says that unless you're in an agreement that says you are not an at-will employee, that you are an at-will employee. So a lot of people don't put this in their employment contracts. But I'm here to tell you that it's important to put this in there to clearly define your relationship, so that there's not any confusion at a later point in time, and there cannot be any argument that somehow they were not an at-will employee. For those of you wondering, an at-will employee is someone that basically can be hired at any time, fired at any time, or the person can join the organization and leave the organization at any time. Basically what you're saying is that we're agreeing to work together, but either of us can end this relationship at any point in time. I also think it's important that employment contracts outline the respective duties of each side to the contract. What is it that you expect your employee to do in this position that you've hired them for? And I'm not talking about your policies and procedures. I'm talking about what it is that you expect the employee to do for that particular position. What are their duties? What are their job responsibilities? In turn, you should also outline what it is that an employee should expect from you as the boss, as the manager, as far as what your duties are. The third issue is confidentiality. Now, in this world of increased competition, confidentiality becomes incredibly important, because in running your business, it is very likely that your employees are going to have access to proprietary and confidential information that give you your strategic advantage in the marketplace. Now, whether this is a formula, whether this is, client lists, customer lists, whether this is software development strategies, or the like. There is a whole lot of confidential information that basically sets you apart from your competitors. So you want to have confidentiality provisions in your contract. Finally, you want to have a non-compete clause, and your non-compete clause needs to include non-competition, non-disclosure, and non-solicitation. This basically will allow you to have some teeth to enforce any breaches of these obligations once your employee leaves your organization. You hope that all of your employees stay, but ultimately if they leave, you want to be able to enforce your rights against that employee if they take your information and try to become a competitor or try to help a competitor. Now, employee handbooks, again, something very underutilized in the market, but there's two issues that I think are very, very relevant to today's business environment. The first one is anti-harassment. If you look in the Federal Registry, the #1 employment claim filed against companies in the United States today is sexual harassment. Now, people joke about sexual harassment, and everybody thinks that they understand what sexual harassment is. But you'd be surprised at how many businesses I have gone to and provided seminars on sexual harassment and how little employees know, truthfully, what it is. I think everybody gets the direct form of sexual harassment. You have to sleep with me if you want this promotion or raise. But what people don't get is the hostile work environment sexual harassment that is created by people sending lewd and obscenious emails, having pictures posted at work, jokes, banter, whistling, other sorts of things that can create an air of hostility in the workplace. So you need to very clearly define what your harassment policies are and very clearly explain to your employees what sexual harassment is, or harassment on all levels, really. The second issue, which is a hot issue today, is email and social media. Now, I think that at this point we all clearly understand that if you are using work email, that email is the property of your company. They have the right to retain it, they have the right to read it, they have the right to use it as they see fit. But social media is a new one. And I've recently read employee handbooks that sort of struggle with this idea. Do we ban people from using Facebook, Twitter, LinkedIn, etc. at work? Can we limit the use of these social media outlets solely for work purposes, for investigation purposes on a case, for instance? How is it that we go about this? Well, the law is very quickly and rapidly evolving in this area. And I can tell you right now that I've read a lot of employee handbooks that have suggested things to their employees about what these policies will be that now appear to be in violation of the evolving law. So I think that this is something that we are all going to continue to grapple with as social media becomes a more important part of our daily lives as well as our business ventures, and we really need to critically think about how to go about using this. Well, I want to thank you for all coming this evening to my presentation on Cornerstones for Successful Businesses. As I said before, I think that these principles will allow everyone to be successful. It doesn't matter if you're an entrepreneur, you're established in already successful business, or if you're looking at a retirement career. I hope that you've all learned something from this presentation, and I would be happy to talk to you about your business needs and your legal needs in the future. Please do not hesitate to contact me. Thank you.